Good morning, friends. Sorry for a little delay. Welcome to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. Today's topic is an insight into private limited companies and key compliances. Friends, it looked very simple topic, but it has a very different color in that. To present this, we have today with us Ms. Tulna Shah, who is handling our Ahmedabad branch. And today's our panelist, Dr. C.S. Yashasri Dikshit. Proud to say doctor. Welcome, Yashasri. Thanks for your time.
Thank you, ma'am.
Dr. C.S. Yashasri Dikshit is a FCS with a PhD in corporate governance. She is lawyer, AMCON, registered trademark agent, and certified independent director. She is practicing CS and leading Yashasri Dikshit and Associates, specialized in secretarial audit, IPR, insolvency matters, corporate compliance for listed and unlisted company. She has rich teaching and training experience in corporate law, IPR, and governance, and has served as a faculty at UG, PG, and professional courses, conducted program for ICSI, ICAI, ICWAI. She has contributed as a MOOC expert at Gujarat University and presented research at national and international forums. Dr. Dikshit serves as an independent director at an Asian Granitor India Limited, Santi Educational Initiative Limited, and Sri Bhagya Fabrics Limited. She is recognized as Top 100 Global Woman Inspiration Award and Woman Managing Director of the Year Award. Welcome, Yashasri. Thanks for your time. We are sure that all participants will gain your knowledge, experience sharing. Our today's presenter is Ms. Tulna Shah, qualified CS and law graduate with 3 years post-qualification experience in corporate governance and other secretarial matter. She has overseen the secretarial function of 200 plus companies and 40 plus LLP, and plays various roles in governance, fundraising, share buyback, investor communication, etc. Our moderator, Mr. Bala and Mr. Sudhakar, everyone knows, I need not mention that. With that, to introduce formally, and we thank all panelists, to introduce our topic on private limited company. As I told, private limited company, every organization has this kind of company, private, public. We talk about a lot about public listed, but the private company is a most happening company where the structuring happens so well and frequently. You have to apply your knowledge and experience for that structuring. The involvement of directors, shareholder is so much, and at that juncture they want to plan their shareholding, their own structuring, their shareholding structure. It involves, because any company becoming listed company is, before that is a private public, then converted into public, and then listed. Majority time it is first private. Rarely, very few companies set up as a public company directly. So this is a base of the company where the company starts to grow, and it involves a lot of structuring and application of mind and various complicated interpretation of statute and law. So we will discuss all that and various exemptions available to private company. And yes, Yashasri is there with us to share her experience. Sudhakar, Bala is there. So with that, I'll request Yashasri to say a few words on the topic, then Sudhakar, then Bala, and then Tulna, you can start your presentation. Over to Yashasri.
Good morning, everyone. And good morning, Sudhakar sir, Bala sir, and Dipti ma'am. This session is basically the private company exemptions. There are so many exemptions in relation with the private company. Certain times we have skipped while filing the annual returns or conducting the board meetings. So in this particular session, we will more focus about what are the compliances that we need to take care in the private company and what are the exemptions that we will get under the private company. Thank you, everyone.
Over to Sudhakar,
Okay.
please.
Yeah. Good morning, everyone. In fact, when we were conceiving this topic, we was wondering that this is a festive time because we had Independence Day yesterday and today Janmashtami. In fact, my best wishes to all of you on the occasion of Janmashtami. So we were expecting that whether to hold today webinar or not, but we thought that no, we never failed to hold the webinar. So we continued to do that. And people proved me wrong that 180 plus attendance when I have seen here. That means there is no occasion whether it for updation of our knowledge. So as far as private companies are concerned, I always divide into two parts: Pre Companies Act 2013 and Post Companies Act 2013. In the Pre Companies Act 2013, the company secretaries used to shy off saying that their company secretaries look after the compliances. Because when I was in Reliance, I used to interview lots and lots of people, and people who used to come prior to Companies Act 2013. They used to say, sir, I am a company secretary of the company, but I don't look after the routine secretarial matters. I look after this, that, whatnot, and all, other than secretarial related matters. That was quite unfortunate. So in those process, they used to lose the core competency, and very few people used to get selected for Reliance, where we requires a core competency on the subject. Whereas post Companies Act 2013, the scenario has completely changed. The intensity of the compliances have tremendously increased. Arduous responsibilities and accountabilities have been entrusted upon the company secretaries. And of course, the deserved recognitions like key managerial person, secretarial audit, all those recognitions have been given. Now, of course, company secretaries very proudly say that, yes, I am the compliance officer of the company. One more aspect is that prior to Companies Act 2013, private company used to have a lot of exemptions and privileges. Very few provisions were there which were applicable to that. So the company secretary was not at all interested in handling private limited companies. To get a company secretary for a closely held group of companies used to be a very tough task. And that's why whenever the regulator used to say under Section 383A, you are not appointed a company secretary, we used to show the advertisements. And then we used to plead to the regulator that, look, we are not getting the company secretaries. Whereas post Companies Act 2013, according to me, handling a public company and a listed company is easier than handling a private company. When I was in Reliance, we used to have some private limited companies in the group. I used to keep an hawk's eye on those compliances of that particular companies. Because if it is a listed company or a public company, everything and anything is applicable to you. You don't need to worry. Whereas if you are a private company, certain things are applicable to you or certain things are not applicable to you, again, subject to some conditions. So you have to be very, very clear that what are applicable to you, what are not applicable to you, and what are not applicable subject to what conditions. So the company secretary of a private company has to read more, according to me, to understand these niceties and nuances than of a company secretary working for a closely held public company or even to a large extent to a listed company. More aspect of Companies Act 2013 is with several sections which were not applicable under the old act becomes applicable. And in that process, three, four important sections, I used to say always the darling of the regulator is these sections. Whenever they come for an inspection or investigation, they used to focus upon these sections. One is section 135, corporate social responsibility, applicable to private companies. Section 90, significant beneficial owners, applicable to private company. Section 188, related party transactions, applicable to a private company. 62, 42, 73, like that, I can say, quote several sections like this, which are very, very important, which were applicable to public companies earlier, whereas those sections are also applicable to private companies. Before I give a pause, I would like to say one thing. in the Companies Act, they have used certain words like certain sections whenever they say a company, and certain section starts with a public company. So you have to understand the difference between this. Whenever in the act it says that a company, it means it is applicable to every company unless until the exemptions are provided with. Similarly, if they say a public company, in fact, there are certain sections wherein they say that within the section itself, in some subsections they use the word a public company, some section they say a listed company, and in the same section, in some subsections they say a company. Take the example of 197. 197, 1 and 2, they use the word a public company. Remaining sections, they use the word a company. Whereas 197, subsection 12, they use the word a listed company. So, of course, different interpretations are there by different people. Ultimately, a company has to take its own call. But whenever we read the Companies Act 2013, we have to read it with full focus, attention. Whether you work for a private company, whether you work for a closely held public company or a listed company. In case you are in practice, if you are having more company secretaries under your fold, please ensure that whenever you read a section, whatever I said, that keep that in mind while reading the section and ensuring the compliances. Never ever feel that if you are a company secretary of a private limited company and somebody else is a company secretary of a listed company, you are maybe at the most a notch below. That same listing regulations may be applicable to them, which may not be applicable to you. Otherwise, you are one among the equals. With that confidence, we have to go ahead. I give a pause here and request Bala to take it forward. Thank you.
Good morning to all of you. I have a great pleasure in welcoming you all on this particular day, especially the Janmashtami. As Sudhagar says, looking at the people's participation, holiday or no holiday, always there is a thirst for learning the knowledge. That is always the case. That is proved actually here. There is one thing. Second thing is Sudhagar talked initially about the 1956 Act, 2013 Act and public company and private companies. I had been working all along my life, about 20 years with the public company. I never had a problem. Those 20 years, I had not even visited the ROC office at all. We have not received any show cause notice. We have nothing. We used to proudly announce in our balance sheet. We do not have any legal issue, no stricture, no show cause notice, nothing we used to publish. But somehow after post-retirement at the age of 67, I took up the job with a group of companies which consists almost about 14, 15 companies which are having a private company, unlisted public company, and the NFSC company and other companies. I worked almost about 5 years. I must acknowledge, received here, whatever the experience I got those 5 years after my post-retirement is enormous. I could learn many things. I was actually amazed and surprised to see, oh, things can go wrong this way also. Oh, these are the things are there. This was actually a learning experience. I always think, learning experience is actually till our graveyard, we continue to learn. This was a very good learning actually. That is one. And second thing is there, as he rightly puts, the interpretation. That is very important because we all start with our company secretary course in our executive program. It's the first topic, constitutional law and the interpretation of the act, actually. Because really many of us don't read even the definition section to understand the things. That is actually the case, unfortunately. Somehow anything is referred, people have to go to the section 2 and to find out what is the definition, what is it, we'll have to go through it, which is actually not happening. But coming to the private companies, it is really walking on a tightrope. Many things can be done, but while doing it, if you commit a blunder, error, then you'll have to pay for it. That is a great issue. As he rightly say, some sections applicable, some sections not applicable, partly applicable. For example, if you come to the appointment of the directors, per se, provision relating to appointment of directors applicable to the private companies. But at the same time, remuneration criteria, ceiling, etc. is not applicable to the private company. They can pay any remuneration. All these things are other intricacies. Today, our presenter is going to specifically she is going to touch upon basically a compliances and also the exemption which are actually available. Probably she is divided into section by section. I think that will give a great learning experience to all of us. As Sudhakar puts it, I would also like to reiterate and emphasize the point, especially the practicing people have to be very, very careful while issuing the secretarial certificate where it is applicable for the private companies, and also other compliances and certification, etc. And all this thing, many things goes wrong. In fact, I had seen the cases, the company where I worked, even the show cause notices have been issued to the practicing company secretary for not doing the job, especially inviting that he is not done as required under the secretary standard 1 and 2, read with the, what you call, the guidance note published by your institute. So we have to be very, very careful while dealing with the public company. That is what I would like to say. With this, I'll ask Tulna to present her presentation. And as usual, participants can actually put up the questions on the chat box. We will be taking it periodically. And at the end, if anybody have a further question, etc., they can raise the hand, then we will permit you to speak, and we will do that like in the past. That's the thing. One more thing I wanted to tell you, many times I see the chat box, can you share the presentation, etc. We already said actually presentation per se is actually not shared. This recorded webinar is actually disseminated, which is available on the YouTube. You can always access the YouTube. It is available, and the presentation contains in the YouTube. Thank you. Over to Tulna, please.
I'll just add that we were not expecting so many participants today. We are really overwhelmed and really happy to see that so many participants are there today, and they were actually waiting for this topic. And I can see the topic is so interesting. That's why the people are there. It is most helpful to practicing CS as well as employee CS as well, because private company not necessarily be a small company. It can be a very big company, and that's why the CS of private limited company with good paid up capital has lot many things to do, and there is no compulsion of having outside people or consultant. So each and every corporate action, bonus, sweat, or reduction, merger, everywhere CS, whether employee or PCS, is working close and as a strategical team with the promoter. And that's why your role is very crucial in private company. With this, over to Tulna. Thanks, participants, and happy Janmashtami and to all.
Good morning, all. Happy Janmashtami to everyone, and welcome to today's session webinar on an insight into private limited companies and key compliances. Yes, a very warm welcome to everyone. So today we will be focusing majorly on the exemptions to the private companies, and this presentation has been made in a certain way wherein all the exemptions have been mentioned section wise, so that you can get an idea about the flow of the exemptions, basically how sections uh, uh, in the act wants to provide the exemptions and relaxations to the private companies. So let's begin. Let's begin with the legal foundation. As per section 2, subsection 68, that provides for the definition of the private company. So a private company is defined by 3 characteristics, that is restricting the transfer of shares, then except in case of one-person company, limiting the number of members to 200, and prohibiting the public invitations to subscribe to its securities. Now, it is also important to note that I've also provided a definition of a public company, because generally public company is not a private company, but at the same time, if a private company by its article has the characteristics of a private company, but still if it's a subsidiary of a public company, then it is considered as a deemed public company. So even though these exemptions which are being mentioned in this presentation are applicable to a private company through its AOA, but at the same time, if that such company is a subsidiary of a private public company, then this all will not be applicable.
1 minute, Tulna. Sorry, I will add today. Sudhakar, I am taking your role. See, friends, the last prohibits any invitation to public to the subscribe for any securities. How a CS play role and how private company become ticklish at certain time. If anything, where you are accepting other than shareholder, the person who is not existing shareholder, it team to breach this. What happens? Breach of any of these three conditions, or especially 1 and 2, or third also number, it will straightway bring it into public. That you have to keep in mind. So any corporate action which leads to or non-compliance, if you do non-compliant in one thing, that will lead me to this non-compliance. For example, this money, if it take the shape of deposit, then you are taking deposit from the company, you have breached this provision, so you become public company, so the compliance of provisions, that is the point. Now, restrict the right to transfer its shares. If the shares are transferred other than what is mentioned in the articles, you have breached. What you have done? You are not private limited. It leads to that kind of interpretation and it has a big impact. You have to understand cascading impact of non-compliance in private company. So this is the starting. This is the practically we have faced, and I'm telling you this. That has impact. So we have to keep in mind, because this line, simple definition, the company which is not private is a public company. So the moment you breach the definition of private company, you are fitting in the framework of public company, and so the provisions of the public company. Okay, Tulna, go ahead.
Well said, Dupti, actually. This particular point, what you raised, which I have actually experienced in those 5 years which I was there. We had a lot of issues with ROC. He actually issued left and right the show cause notice. You are the public limited company now. You have to comply with 1, 2, 3, 4, 5, 6, 7, 8, like that, etc. It is a marathon exercise for us all that has happened actually. You well said, really. Yeah.
There is 2 more aspects here.
Yeah.
One is that when a private company gets converted into when it becomes a subsidiary of a public company, under the Act, there is no mandate that private company has to convert into a public company. So it can continue to have that word private in the name of that company. However, all the provisions whichever are applicable to a public company continue to applicable to that particular company. And just this company can continue to have restrictions as far as the share transfers are concerned, as far as deposits of acceptance of public deposits are concerned. Several times this question has come up, whether such companies need to have, when they're continuing with the word private and not converted into a public company under the Act, whether they need to continue to have 2 directors or they have to have 3 directors. Whether it can continue to have 2 members or it has to have 7 members. Answer to that is, as I mentioned, that all the provisions applicable to a public company, it will be applicable to this company which has become subsidiary of a public company. So you have to have 3 directors. And you also have to have 7 members. The reason being, even to hold a general meeting, the quorum is 5 members. Suppose if at all you are interpreting that you can continue to have 2 members, it is not possible. For quorum, you have to have 5 members. So as far as directors are concerned, shareholders are concerned, you have to have as if it is a public company and all the applicable provisions of a public company continue. Only privilege what you have is that also because most of the times the private companies are joint venture companies. In the joint venture companies, one public company may have 51% and other company, the joint venture partner may have 49%. in such case, this company becomes a subsidiary of a public company if that 51% partner is a public company. If you are not having this kind of provisions, it will put them into difficulty. That is the reason in the Act it is clearly there that there is no mandate to convert the company into a public company. It can continue to be a private company, can have the restrictions, but all other provisions of public company are to be applicable here. Number one. Number two, as we know that as an individual, I can have 10 directorships of a public company and 10 directorships of a private company, maximum of total 20. One has to be very careful because if you exceed this limit, you will become disqualified to be a director of any company. And one has to be careful because it may so happen that you are a director of 10 public companies and 10 private companies, and any of the company becomes a subsidiary of a public company. Immediately, you have to ensure that you have to bring your directorships of public companies that to 10 companies only. That means you have to resign from one public company so that you are from this company itself so that you won't get that disqualification provisions attract to you. Thank you.
In addition to Sudhakar sir, when your company is a deemed public company, again the dematerialization of securities must be required. So they have to fulfill this law, and filing of the MJT 14 form is also compulsory, and they have to immediately increase the directors from 2 to 3 and shareholders from 2 to 7. So it's quickly they have to do such kind of process, and they have to also take care about section 180 provisions in that.
Thank you.
Well said. Well said. Well said.
There is a question that can you elaborate on the restriction on right to transfer the shares? It's in your article, it is mentioned, and whether it prohibits any unsecured loan from other than members. It's basically I given the deposit. See, the last provision says prohibit invitation to public to subscribe any securities. So if the person is not existing person, or sometimes deposits, the color takes the, that borrowing takes the color of deposit. I just given that kind of example. So it is a facts and circumstances. We have to say that. I was intending to tell that this A, B, and C, we have to take care what is mentioned in our article and follow that. Of course, any invitation to public to subscribe security of private company will turn it into public company. Yeah, thanks. Yeah, Tunu.
Okay, so the private companies get these exemptions through notifications of MCA, and the MCA gets these powers through Section 462 of the Companies Act. So, majorly there are three notifications which provide exemptions to the private companies. So, the very first was in 2015, which was the foundation legal instrument for most private company exemptions. Then came uh, two notifications in 2017, which provided further exemptions, majorly focused on amendments for deposit rules and exemption to the startup companies. Then the next notification came in 2021, which extended the exemption to private companies, to startup companies for the convertible note. So all these exemptions are provided in these notifications, but there is one condition. So an important point to be noted is these exemptions are conditional. They are available only if the company has not defaulted in filing financial statements or annual returns with the ROC.
So even a single year failure will make them ineligible for this exemption.
Yes.
So the level of compliance expected from private limited companies is quite high.
Although you may have a lot of exemption, but whatever the complaints are there, that is strictly to be adhere. If you fail to do that, then you lose all the exemptions. That is the thing.
Yeah, so but the thing that if you default any year, the impact is not only late filing fee and all that, this exemption unavailability. Yeah, please.
Yeah, so now we will start with the exemptions to the private companies under the Act. And the very first is exemption from filing cash flow statements with ROC. So this exemption is applicable to one-person company, small company, dormant company, or a private company that is recognized as a startup. So this exemption provides ease in disclosure requirements and lowers the compliance cost for such private companies. It is important to note that the small company is a public company other than a public company and which has a paid up capital of up to 4 crores and turnover of up to 40 crores. And a dormant company is also is as specified in section 455.
Yeah.
Now, here in this case, you should take note that if your company is a private company, but other than public company, and your company is a subsidiary company, or if it is a Section 8 company, then they are exclusion under the part of the small company. So again, they have to comply or attach this cash flow statement. So they have to not applicable this exemption. Because small company, they are exception that this clause is not applied for the holding company, subsidiary company, and Section 8 company.
Can you repeat, yes, what you said, please?
Yes. So a small private company, if it is a part of the small company, now in the small company definition, there are exclusion that this small company, it's not applicable if this company is a holding company, subsidiary and company, and Section 8 company. So if your company is a subsidiary company of the public company and a Section 8 company, then they have to file this cash flow statement. So this clause is also not exemption, they cannot avail. So this is my concern.
But they are not.
Deepti, what Yashasvi says is that, yes, it is right. In fact, you have to be careful, even if your company is a private company. If it is a small company or a one-person company or a startup, then certain privileges are available. That suppose, okay, by financial statements, if you see the definition, cash flow is not a part of the financial statement for these companies. For other private limited companies, financial statement is a part of the definition of financial statements. That is what it is.
Yes.
That is the reason what I said in the beginning itself. Don't take the exemptions to private companies per se. You have to be careful that these kind of niceties which are there, which are hidden rather. Some are through circular, some are through rules, some are directly in the section itself. So, according to me, handling a private company these days is riskier than handling a public company. That's why I cautioned in the beginning itself. Because I suffered when I was in Reliance. I left some private companies to my colleagues with all due regards. There was a fox pass somewhere, which would have put us into trouble had I not seen that. After that, I have become more careful. Yeah.
So cash flow filing is exempted only to small company, right?
Yes.
There are people differing. And also Section 8 company, it is not exempted. Even if you are small, but it is not there. Yeah. Mr. Rajiv is differing. Okay. But the section is still. Yeah. Yeah, Tulna.
Yes. Another important exemption is in related party transactions. Normally, related party dealings require
One
approvals
minute.
and
They are telling which are the company regulated under special act. The act, like, for banks specifically, the acts are there. For many companies, the government come out with the act. That are the company. Yeah, carry on.
No, Sthiti, as you rightly said, when you say private companies, certain things are not applicable. When you talk about the sectoral regulations, as you said, if the RBI is actually regulating a private company, which is registered as the NBFC company, then naturally all the sections of 177, 178, the committee appointment, everything is applicable under the Companies Act. We cannot say that, private companies are exempted from appointing the committee because you are registered with the RBI. So likewise, you have to see every sectoral regulation, what are specifically applicable, that has to comply with that. Yeah.
Yeah, Tulna, sorry.
yeah. Normally, related party dealings require approvals and disclosures, but for private companies, transactions with holding companies, subsidiaries, associate, or fellow subsidiaries are not treated as related party transactions. These save significant compliance effort because for a private company, its holding company, subsidiary, associate, or fellow subsidiary are not treated as related parties per se. So it gets exemption from getting approvals under Section 188. So for this exemption, generally now private companies are also under the purview of getting their securities dematerialized. But if such private company is a small company, or if such company is not a holding subsidiary Section 8 or Special Act company, then it is not required to issue its securities in dematerialized form.
So
Otherwise,
different exemption.
yeah, otherwise even the private companies are required to dematerialize.
Hmm.
So, private companies have flexibility in designing their share rights. They can issue shares with differential voting rights or different dividend rights, provided their article of association allows it. This means founders and investors can customize ownership structures without following the stricter procedures of public companies. However, compliance is like filing with ROC and maintaining registers still remains mandatory.
So here I was telling that, people keep the private companies with big paid up capital also. And a lot of operations, very big companies are also private because they have full freedom to structure their shareholding and work out the investors in their own way they can bring it. That structuring of capital is very conveniently done in private companies. Yeah, Tulna.
So, for further issue of shares under Section 62, subsection 1A, that is for rights issue. So, for rights issue, generally the company uh, sends the notice to the existing shareholders, wherein the rules provide that the notice period for such issue has to be minimum of 7 days and maximum 30 days. But if 90% of the members of such private company agrees that they want a lesser notice period, say for example, they need the notice period to be of 2 days, even for 1 day, they can do so by agreeing 90% of the members, and even they can close the issue in 1 day, 2 days, and they can infuse the capital and faster the process of allotment of shares. So for ESOPs, generally employee stock employee share stock options are to be approved by the company through a special resolution, which requires 75% of the consent. But for private companies, this requirement has been relaxed, and the company can approve its ESOPs through auditory resolution. This lowers the barriers in introducing the ESOP schemes and potentially helping the talent retention and attraction. For in the same uh, line, for further issue of shares in ESOPs, private companies which are recognized as a startup, generally the promoter group and the director who directly or indirectly holds more than 10% of the equity shares is not eligible for ESOPs. But the exception is if the private company is recognized as a startup, then it can in fact provide ESOPs to its promoters and directors holding more than 10% of the equity shares.
Okay. Tulna, just a minute. While section 62, subsection 1, subsection A, here they have mentioned 90% of the members to have consented to the shorter timelines. So here there is a one confusion that whether 90% of the members, that means 90% by the headcount or 90% by their value. So here I've clarified that the 90% of the members, that means 90% of the members by the value of the shares held by them, not the number of the shareholders present in the company.
Okay.
Yes, Sulna.
Yes. Should I proceed with the next slide?
Yes.
Yeah,
Right.
please.
Yeah. For section 67, that is restrictions on purchase by company or giving loans for purchase of its own shares. So generally, a company cannot buy its own shares unless it is a buyback as per section 68. And in section 68 itself, it provides the restrictions on a public company. But the provision wherein it states that it has to go through section 68, that will be relaxed for a private company if the private company meets these conditions. That is, it does not have any body corporate as its shareholder. Then the borrowing from banks, financial institutions, or any body corporate is less than twice of its paid up share capital or 50 crores, whichever is lower. And such company has not defaulted in repayment of such borrowing subsisting at the time of making the transactions. Hence, founders or existing shareholders can arrange financing for incoming shareholders without breaching the law. Yes. So now, section 73, subsection 2 deals with deposits. So there are certain stringent deposit rules which are applicable once the company intends to take up deposits. But for certain eligible private companies which fulfills these criteria as mentioned in the table, they can accept those monies without following those rules, but at the same time they have to comply with the disclosure requirements and have to file it in DPT3 annually. So the restrictions or the rules which were to be followed and what are exempted are in the next slide. So generally, if the company intends to take up deposits, it has to get the members' approval. It has to circulate financials, credit ratings, and deposit history to its members and file it before the ROC. Then there's a requirement for maintaining deposit repayment reserve and have to check about the previous defaults and borrowing limits and all. But if the company is a eligible private company as mentioned in the previous slide, all these requirements are done away with, except it has to file the disclosure in DPT3, return of deposit. Under the rules for deposits, so there are certain exemptions which are certain receipts of monies which are not considered as deposits. So for a private company which is recognized as a startup, for such companies, if the startup wants to take up money in the form of a convertible note, then it has to comply with the condition that such money has to be at least minimum 25 lakhs per investor per tranche and has to avail all these funds in a single tranche. So if all these conditions are complied with, then such money will not be considered as deposits, but at the same time, it has to disclose it in Form DPT3. This expands the funding sources for startups and reduces compliance burden. Now, for other private companies, including startups and all the private companies, the private companies can accept money from its directors and relatives of directors, and such money will not be considered as deposits. But there is one condition that the money which is being given by the directors or relative of such directors, the person giving that money has to declare that all this money is being given from their own fund and not from borrowed funds. Of course, the disclosure in DPT3 still has to be given, and it has to be also mentioned in board's report. It is also to be noted even though such receipt of funds will not be considered as deposits, but if it breaches the limits under Section 186, then the company has to go to the members for getting the approval of the shareholders, and all those compliances are to be done, filing of FGT 14 and all the related compliances, even though such amount will not be considered as deposit. So for annual return, private companies are not required to disclose the individual amount of the remuneration given to each director. In fact, it can just provide the aggregate amount of remuneration drawn by the directors in total. Other than that, for reduced compliance burden and flexibility for private companies, the annual return can be signed by the company secretary, or where there is no company secretary, by the director of the company. Otherwise, generally, the annual return has to be filed by the director and the company secretary, and where there is no company secretary, it has to be signed by a practicing professional. Yeah. So for holding the meetings of general meeting, that is AGM and EGM, generally the Act provides for a provision of notice period of 21 days, 21 clear days. But if the AOA of the company provides for a shorter period, say for example, if AOA of the private company says that you can call a general meeting in 7 days, then the notice period for the AGM has to be 7 days. But it has to be noted that if the board wants to call up the meeting for in a period lesser than that is provided in the AOA. Say, for example, AOA states 7 days and the company wants to hold up a meeting in 3 days. Then the provisions for getting the consent of the members for holding meeting on shorter notice period has to be complied with. So it provides operational flexibility, and once the shorter period is mentioned in the AOA, the 21 clear days are not required to be followed.
Well said, actually, Tulna. Well said, actually, Tulna, as you rightly brought out. As add to my experience, first time only I have seen that the AOA is giving a lesser period. That also I had seen the different period. 7 days notice, 10 days notice, 15 days notice, 14 days notice, etc. Another thing and all. In fact, this is the added experience when I joined at a later portion actually. And as rightly said, people wanted to have a board meeting in the morning. They want to call a general meeting the very next day. Then if it is a 7 days is there, even then, that shorter notice consent was actually required. That is also there. You well brought out this issue. Yeah.
Thank you, sir. Yes.
Now the shareholders, the meeting also can be held out of India also. For a private limited company, if you wanted to hold a shareholders meeting, you can hold it outside the country now. I think it is allowed.
It can't be. It can't be.
It can't be. I believe there is some MCA circular which says that it can be allowed. Anyway, we can just take it out Tulna.
Sure.
Whatever my memory goes, AGMs have to be held within India only.
Okay. Or maybe EOGM, can be held outside India.
EOGM maybe. EOGM
Okay,
maybe,
EOGM,
but
okay.
AGMs have to be held within India.
Okay. I just stand corrected. It is EOGM. Yeah.
Yeah, you're right actually. EOGM is permitted, AGM is not. Yeah.
Yeah.
Okay.
Yeah, Tulna, you can continue.
So section 102 deals with explanatory statement to be annexed to the notice of general meeting. So if the AOA of the private company provides that the explanatory statement is altogether not required to be given, or if there are certain relaxations to the points which are provided in the Act, then the company can just follow those relaxed requirements as provided in the AOA. It is to be noted that the AOA has to explicitly state what all can be relaxed and what all has to be included. Otherwise, in case of AOA is silent, then the section of the Companies Act will apply.
Again, Tulna, going back to the incorporation of the companies, many of our practicing people, they are actually helping in incorporating the company, private company, etc. So it goes, beyond doubt. While incorporating the company, the drafting of the articles of the company is very, very important. Clearly spelling out what are the things what you want to do, what are the exemptions you want to have, what are the things you want to have. That is very, very important here. I think doctor can add on this because she has been handling many companies. And your view, please, on this. Drafting of articles.
Yeah, yes, see, you want to comment on this drafting of article, please, of private company?
Yes. While the drafting of article of association, we need to take care the considering the notice of sending the board meetings, extraordinary general meetings, and explanatory statement. So if we have not mentioned in the article of association, then we need to follow the Companies Act 2013. So at that time, we have not written. Then it is a challenging part that whether we have to applicable under the provision of the Companies Act 2013 or what. So we have to take care much while the incorporation of company and drafting the article of association.
In short, don't do cut paste of the article of other company. Whatever exemption and all that are available, keep in mind so that in future, you by writing common word, you are not subject to comply with other compliances also. Okay, thanks.
Yeah, in addition
But
to
since
that, I said earlier the deemed public company. So when the company is a deemed public company, so they have to start the alteration of article of association and they have to mention the clause of the public company in the same.
see, two things I want to say. Number one is that though we are using the word deemed public company, that concept is not there in Companies Act 2013. That concept was there in 1956 Act. There was a deemed public company concept under the old Act. Under the
43A.
new Act, only two types of companies are there, private company or a public company. But sometimes we are using the word deemed public company, but that concept is not there. Number two, Atulbhai, you have raised this issue of AGM. For the benefit of the participants, I would like to just read the section 96, subsection 2. Every annual general meeting shall be called during the business hours on any day that is not a national holiday and shall be held either at the registered office of the company or at some other place within the city, town, or village in which the registered office of the company is situated. Provided that AGM of an unlisted company may be held at any place within India if consent is given in writing or by electronic mode by all the members in advance. This is what the provision is. So AGM has to necessarily be held within India only. And in case of every company, it is within the where the registered office is situated. Only in case of unlisted company, with the consent of the members, you can hold the AGM at any place within India. That is the difference. But anyway, now in the case of this virtual meeting, this particular provisions have little relevance till 30th September 25. After that, unless until the circular is extended, you cannot have that virtual meeting concept.
And one more thing, Sudhakar, to supplement what you said, actually, the meeting can be held within the city anywhere which is permitted. To determine within the city limit, there's a circular is also there, MCA, which actually say that you have to take the postal pin code, which is actually of that area. First 3 digits of the pin code, whichever is the common, that will be actually applicable within the city limit of the things. Yeah. Yeah, Tulna, you can go ahead.
Yes. So, from section 103, the procedural part of holding the general meetings and board meetings and everything starts up. So, generally, 2 members present at the meeting shall be the quorum for a general meeting of a private company. However, if the AOA of the company provides for a higher number, then such higher number can be considered for the purpose of quorum. At the same time, for chairman of meetings, if the procedure for appointment of chairman for each meeting is provided in the AOA, then that has to be considered. For proxies, the proxy provisions are provided in section 105. Those provisions are to be followed, but if the AOA provides for certain relaxations or certain restrictions, at the same time, then such provisions of the AOA shall prevail. So basically, the section has empowered the company to give relaxations or give stricter provisions in their AOA, but at the same time, the company has to specifically provide it in its AOA. Otherwise, sections will prevail.
Okay, noted.
Same goes for voting rights as well. So generally, a company can restrict voting rights of a company if the called amount of the shares is unpaid by the members, or if the company has to exercise lien. But if the AOA relaxes these conditions, it can modify or delete such restrictions, and even if the called amount of the shares is unpaid, then even then the member can vote on the matters in the meeting. But the AOA has to provide it. Now, Section 107 deals with voting by show of hands. So, there are various methods for voting on the matters, and there is a chronology which has been provided in the Act. If the AOA provides for a different set of voting methods or a different chronology, then the company can do their voting procedures in accordance with their AOA instead of following the chronology and the methods provided in the Act. Now, for Section 117, subsection 3, clause G, there are certain resolutions which are passed by the Board of Members under their powers of Section 179. So, generally, all the resolutions passed by the board under those powers are to be filed with the ROC in Form NGT 14. But for private companies, they are exempted. So the board resolutions are not filed, and it becomes a sensitive business decision, and that remains confidential. As if we file the resolutions on MGT 14, it automatically becomes a public document.
Tula, 1 minute. Like, see, I was telling structuring and drafting article. If you see that voting by show of hand and demand for poll, if you mention procedure, now if a promoter wants to control by voting rights only, means voting power, they can say the poll will be there always. So that kind of structuring, so you have to work with, and you can do a very good structuring as regards to the shareholding rights, share capital in the private company. Yeah, Tulna, go ahead.
Just a minute, ma'am. Here in the section 108, that is regarding the e-voting. So the private company can also do e-voting. If the members are less than 1,000, then they can exercise this option electronic at the general meeting. And one more point, that is section 138. So 141 before that, 138 is an internal audit. So all the companies only the private company, in the definition of Rule 13 of the Companies Accounts and Rules 2014, they have mentioned that only the private company having the turnover of 200 crores on the preceding financial year and outstanding loans and borrowings from the public financial institution exceeding 100 crores or the more, that companies are also required to appoint the internal audit. So we should take care that the private companies are also required to appoint the internal auditor.
Very good point. Yeah. So you have to keep eye on your turnover and all. Yeah. Yeah, Tulna.
Yeah. So now in section 141, subsection 3, clause G provides for ceiling on number of audits which an auditor can take up. So general rule is that a statutory auditor can do audit of at most 20 companies, but those 20 companies will not now include OPCs or dormant companies, small companies, and private companies having paid up share capital of less than 100 crores. So a auditor can in fact take up more than 20 companies provided the other companies and including these companies, the cap is not breached.
Okay, just one more minute. In addition, in the section 139 subsection 2, we should take care while appointment of the statutory auditor in the company, there is one provision 139 subsection 2. In that they have mentioned all the private limited companies having the paid up share capital of rupees 50 crores or more or the public borrowings rupees 50 crores or more, they should not appoint and reappoint individual as auditor for more than term of 5 consecutive years, and in case of the firm then not more than 2 terms of the 5 consecutive years. So this provision is also applicable to the private companies. So certain times we should also consider that this provision is only applicable for the public company, but there is some restrictions and this provision also applicable to private companies if these conditions are fulfilled.
Basically, they want to target the companies which are bigger in turnover and paid up capital to cover under the more compliances. We can say that way. Yeah, Tulna.
So next is disclosure in auditor's report. So section 143, subsection 3, clause 1 says that the company is not required to disclose whether the company has adequate internal financial controls with reference to financial statement in place and the operating effectiveness of such controls. So the generally the auditor is required to give such disclosure, but for private company it can skip this part and not provide altogether a disclosure on this point. Now for section 149, which deals with board of directors, the company is not required to, private company is not required to appoint an independent director and a women director. But if the company voluntarily appoints such director, then all the applicable provisions are to be complied. Now, section 160 deals with rights of person other than retiring directors to stand for directorship. So generally, for getting the candidature of director in the company, the candidate has to deposit 1 lakh rupees, and there are provisions wherein such has to be refunded and all. But altogether, if it's a private company, the requirement of providing or depositing such 1 lakh for getting the candidature of a director is omitted. So in private companies, the directors need not to give 1 lakh rupees for the candidature. In section 162, which deals with appointment of directors to be voted individually. So now it's a different aspect. So now the section states that the appointment of each director has to be taken separately, but then the exemption is given to a private company that they can appoint multiple directors in one resolution. But if we read this with secretarial standards, then secretarial standards primarily provides the framework which requires that each item of business is to be taken up by a distinct resolution. So by following the stricter norm, we believe the secretarial standards are to be followed, and it is better if we appoint separate directors in separate resolutions.
So
Not
Sudha,
it is better. Not it is better.
Not
It is
only
mandatory.
not only it is better, it is definitely mandatory because SS1 is actually mandatory. So SS1 is actually giving what you call a supplementary or complementary role to the company law provisions. So you have to go by the secretarial standard only. That is the
the act only, no part of that.
correct. Because this has been mandated. If you
Now
read the
that there
section,
will be debate whether secretarial standard is above the act.
it is
So
not
that
above the
can-
act, it is within the act. Because it only give you clarification and it
So you
supplements
can
the
say
act.
contradictory sometimes provisions are there. Contradictory.
See,
Not
no, no,
just stricter provision. Stricter
see,
provision.
the answer to the people who say that is it secretarial standard over the act, above the act, or a contrary provisions and all, how can one say that it is a part of the act?
Correct.
Just
That's
like
right.
the way the rules are part of the act, similarly, secretarial standards 1 and 2 are also part of the act. So there is no question of any overriding or above the act or below the act and all. It is a part of the act.
Yes, go ahead,
Okay.
Sudha.
Yes, sir. Now, for section 173, subsection 5, that deals with frequency of board meetings. So, for private companies which are recognized as startups and for one-person companies, the frequency of board meeting has been reduced to 2 meetings per year. But the condition is if only 2 meetings are held during the year, then there has to be a minimum gap of 120 days. Now, for section 174, subsection 3, that deals with quorum for board meetings. So, generally, interested directors are not included for the purpose of quorum, but for private companies, interested directors may be included and they can be counted for the purpose of quorum, given that the interested director has disclosed his interest in the item pursuant to section 184. This makes the decision making faster and reduce the operational hurdles for closely held companies. Now, for section 177 and 178 deals with audit committee and nomination and remuneration committee. Even though private companies are exempt from from the formation of such committees, if they are regulated by any of the regulatory, say for example, it's an NBFC companies, and then they are required to form audit committee, NRC, risk management, all those committees, then the applicable provisions with respect to such committees will be applicable.
Can I add something, Tulna?
Yeah,
Sure, ma'am.
sure.
Sure,
Yeah.
ma'am.
Sure.
Yeah.
Anytime.
Yes. So just we have skipped 3 points. That 164 subsection 3 that says about the disqualification for the appointment of director, and section 167 subsection 4 which says about the vacation of office of the directors. So in that section they have specifically provide that the private company can provide in the article of association for some more disqualification for appointment as a director in addition to those that is mentioned in the 164 subsection 1 and 2. So private company can amend the AOA accordingly, and in case of the vacation of office of the directors, again the private companies may add its article of association for certain other grounds, terms and conditions for the vacation of the office of the directors other than mentioned in section 167. So this two provision we should take care. And the third thing, section 177, subsection 9, that vigil mechanism, and in that rule 7, sub-rule 1, companies meetings of board and its powers rule. So vigil mechanism is also applicable to the private company if they borrow money from the banks and financial institution, it exceeds rupees 50 crores. So we should take care while drafting the board of directors report.
Doctor, again, you have brought out the very good point, because how important in drafting the article of association while incorporating the company. That is the point which is actually coming again and again. So we'll have to be very, very careful in our drafting skills. We'll have to understand, having a proper meeting, what exactly they want, what is the exemption, what are the restrictions, etc. We'll have to understand accordingly. The drafting is required to be done. Yeah.
Yeah, and one more practical experience. In the AOA format, they have not specified to borrow the money from the bank and financial institution. So recently, I have experienced that the bank has specifically asked me that in the article of association where this clause is mentioned. So in the last, I would suggest the others, we have to select the others. In the last, we have to mention that the company can borrow the money from the bank and financial institution. So in the next time when we are going to take the secure loan from the bank, so they need to check this provision.
Yeah, this was a standard thing, and then you have to explain bank that it is bank is not prohibited, it's a loan is allowed and all that. But then they insist in the article, so we generally put it, but rightly you pointed out that better you specify, otherwise banks raise this issue. You rightly pointed out, yeah.
Dipti, it is very difficult to convince to the banker people because they don't understand the Companies Act. That's the whole problem.
That's why in our standard format, we always mention that the company can borrow from the banks and financial that way. Thanks.
Sudhakar, you want to add something? Yeah.
Sorry, Bala, go ahead.
No, you wanted to add something.
Yeah. Two things I want to add. Number one is that when we are talking about the drafting the articles of association of a private company, what is important is not the drafting skill. What is important is a thorough understanding of the comprehensively provisions of Companies Act. The second thing is also I would like to submit to all the participants in case you have private companies under your fold, maybe after this webinar, because I have seen several appreciations out there, but what I also request all of you is, and please review your articles of association when you go back to your desk tomorrow. Once again, keeping whatever the provisions we are discussing, those provisions are properly there or not there, issues are addressed, not issued, or any kind of amendments are required. If any amendments are required, we are around the AGM time, so you can act upon immediately on that. Thank you.
Everyone is going to do that, Sudhakar. And in our organization, I have specifically instructed everyone, if you are dealing with private company, you should be reading article first before you start the work. There is something unique you will find always in article. Or they have drafted themselves for their own structuring, or there is a mistake. People has done cut paste, and that has the implications that we think that private company this is not applicable, but the thing is something different. So that to be kept in mind while article of private company is really Pandora box.
But I don't know whether we have a Deepti, I don't know whether we have a template in place or not. If not, let us have that thing at least.
Yeah, we have that. That's why I told we standardized. We always put that banking. Over the years, we have developed that. Yeah, thanks.
You have a very typical articles, whenever you have a joint venture or two partners, company. So that time, of course, you just can't take things, as for the Companies Act. Someone has to read those articles because articles always say, look, two directors from group A and two directors from group B, unless and until it is present, so then only it becomes a quorum. So yes, the Companies Act allows this kind of a provision also in the articles. So the articles are very unique, in case particularly when you have a joint venture company or a two partners company or some kind of external agencies are involved. Thank you.
Yeah, the good one. So that's why all JV companies are private company, because they can work as per their requirement. And one has to be, as you know, that now it is not to be mentioned, JV agreement, that crucial terms should be part of article to be effective, as everyone knows that. But while doing that, keep in mind these exemptions, implications, so that it does not conflict. So while drafting or finalizing agreement also, that all we have to keep in mind. Yeah. Yeah, Tullang, go ahead.
Yes. So now section 180 deals with restrictions on powers of board. So generally there are certain transactions which are covered under section 180 which are to be done through shareholders approval. I have listed out those. So it relates to disposal of undertakings, borrowing beyond limits, and a remit debt due from a director, and investment of compensation acquired from compulsory acquisition. So in non-trust securities. So basically these are all the transactions which are generally to be done through shareholders approval, but for a private company, these transactions can be dealt with through board, and board can take decisions without a shareholders resolution. It offers smoother operational flexibility. Now for section 184 subsection 2, that is disclosure of interest by directors in contracts or arrangements. Interested directors generally are not considered for participation in the meetings when that particular item is taken up. But for private companies, interested directors can definitely take part in the meeting and vote as well. And the condition for that is the interested director has to disclose his interest. Now for section 185, that deals with loans, guarantees, securities to directors and entities in which directors are interested. So generally, the company cannot give loans, loans, guarantees, and securities to directors, but there are certain restrictions and conditions. So, for a private company in whose share capital no other body corporate has invested, or if company has to comply with all these conditions, and if the company has a borrowing of less than twice of the paid up share capital or 50 crores from banks, financial institutions, or other body corporates, and the company has not defaulted in repayment of such borrowings subsisting at the time of making transactions under 185, then the company may give loans and guarantees, securities to such directors without complying with Section 185. That is, without getting the approvals from the shareholders. But at the same time, if the limits of Section 186 are considered and those are in breach, then of course the shareholders' approval has to be taken, and the MGT 14 has to be filed, and all those compliances are to be done.
Yeah. So now I would like to add one thing here, that in case of Section 185, when the exemptions are available to that company, it can give loans to its directors and their relatives. A question comes that during the tenure of the loan, after the loan is given to them and all, and suppose the repayment is, say, about after a couple of years, and during this period, these exemptions which are there, they have been now breached. Whether that loan is to be taken back, answer is no, because these conditions are to be applied only at the time of giving the loan. Once the loan is given, during the course of the period, if that exemptions are not available, but still that loan will be taken, repaid only after completion of the term. However, you cannot modify any of the terms once the exemptions you have breached. Okay, but 186, as you rightly said, it will be applicable from day one onwards. Yeah.
Now, for Section 188, subsection 1, second proviso. So, Section 188 deals with related party transactions, and generally, the related parties are not allowed to vote on RPT transactions. But for private companies, majorly it's a closely held group, and mostly they are in fact related parties. So, this restriction has been relaxed, and related parties members can in fact vote on RPT resolutions for shareholders' approval. But that related party relationship has to be mentioned in the minutes of the meeting. Now for Section 196, subsection 4 and subsection 5, that deals with key managerial personnel, that is KMPs. So the appointments and reappointments can be finalized at board level. Generally, the appointment of managing directors, whole-time directors, managers are to be approved from shareholders' resolution. But for private companies, it can be done so through board level. And the terms of appointment, remuneration, and all such terms are not applicable to the private company. So the private company can set their bar as per their requirement. But the AOA has to provide for such conditions. And if there's a shareholders agreement in place, then the terms of such shareholders agreements has to be incorporated in the AOA to make them effective. So we are at the end of the presentation here.
Okay, we will go through the chat box, whatever the questions are there. We'll
Yes.
start with it. Yeah.
Before that, just I
Sharing
need
the
to write some
presentation.
section.
Stop sharing your screen.
Yes.
Yeah.
Can I add more section in
Yes,
that?
yes, doctor. Go ahead.
Yes. So, sir, section 190, they have provided the contract of employment with the managing and whole-time directors. So, again, this provision which is not applicable to the private company because they have specifically mentioned in section 190 because private company is not required to maintain the contract with the service with the managing directors or the whole-time directors, and they have no right to inspect the same. And the 197 is also not applicable to the private company. And yes, there is important provision section 203, appointment of key managerial personnel. Here we should check under Rule 8A of the company's appointment and remuneration of the managerial person rules 2014. They have specified one condition for the private companies. So appointment of MD, CEO, manager, whole-time director, CEO is not applicable. However, all the private companies having the paid up share capital of rupees 10 crores or more is required to appoint the whole-time company secretary in the private company also. So this is when the private companies who's exceed the paid up share capital of 10 crores and they have to appoint the whole-time CS in that company also. And 204 secretarial audit is also not applicable to the private company.
In fact, in the 203, there is an issue there. When that private companies have to appoint a company secretary under the Rule 8A, a question has come up because under Section 2, subsection 52, company secretary is a key managerial person as per the definition. So whether 203 is to be complied with or not, normally in general we say no, 203 is not applicable. But unfortunately, NCLAT has taken a view that the moment company secretary, it is falling under the definition of key managerial personnel, and 203 talks about appointment of a full-time KMP. Here also it is a whole-time company secretary, so they have to comply with provisions of 203. It is that matter is yet to be, if I am not wrong, it has not been taken up with at the Supreme Court level. But as of now, this also is becoming an issue, unfortunately.
Yeah, as you rightly said, Sudhagar, by virtue of the definition itself, the moment you appoint the company secretary, he is the KMP. That is the way the definition actually goes. Yeah.
So in case any private company or any company to which 203 is not applicable, say for example, a company, only 8A talks about the appointment of a company secretary, not about the CFO. Say for example, a company to which 203 is not applicable, they voluntarily appoint a CFO. They have to necessarily comply with 203 provisions also, as on date, as per that NCLAT order. So one has to be careful about it. So voluntarily, even if you do certain things, you have to comply with the provisions. Say, for example, if you constitute an audit committee, NRC, SRC, or CSR, whatever it is, all these committees. The purpose, the rationale for that is why, and I'm creating it voluntarily, why I have to comply with the provisions of the Act. The rationale for that is you should not deceive the public by saying that, look, I have all these committees and you are complying with the provisions at your whims and fancies. So public is under the impression that you have audit committee, you have an NRC committee and also it is virtually amounts to a cheating. That's the reason what they say is even if you are having all these committees on a voluntary basis, you have to comply with the provisions. So please ensure that.
Well said, Sudhagar. Because as I was telling you, we had an independent director in a private company. Before appointing the independent director, I have been asked the question. So we want to appoint the independent director. Can we appoint the independent director? I told very clearly, you can appoint the independent director. The moment you appoint the independent director, all those conditions which are actually specified in the Companies Act will become applicable. So we'll have to take care of the compliances. But anyway, they wanted to go ahead with the better corporate governance, have a control over that. So they gone ahead the independent director and we are complied with all those things there. That is the thing. As you rightly say, even if you do voluntarily,
recently somebody has brought to my notice that some senior company secretary or some senior lawyer has given a legal opinion about this. I mean, look, even in case of voluntary committees, you don't need to comply with provisions and all. See, as far as the legal opinions are concerned, it is an opinion of a particular person. Okay, so you have to be very careful. You have to understand the regulatory mindset, according to me. If any kind of already adjudicated orders are there or any case laws are there, better to interpret the section in light of the same. Otherwise, what happens is even if you are taking a shelter of a legal opinion, it may not have legs before the judicial authorities are adjudicators. Be careful about that.
Yeah, Mr. Bala, you can start the questions.
Yeah. Can you have the recorded version of the traveling? Yes, I already said in the beginning only, it will be available, it will be disseminated. Anybody can have it. Query to reference to the exemptions, notification dated 5th June 2015 issued in the private companies and Section 8 companies, whether Section 8 private company can avail exemption granted to private companies.
In the slide, it was mentioned one exemption where it is Section 8 company, the exemption is not available. As regards this particular circular, Yashasvi, you want to comment?
He talking the circular of 5th June 2015, he is talking about it.
Honestly, circular, I don't know, but if the circular is silent, that Section 8 only private company is entitled and it's not carve out Section 8 company from that exemption. If your Section 8 company is private company, you can avail.
Yes.
I'll
Because
put
the
that.
circular has not specifically mentioned the Section 8. The circular is specified for the private company. So I
And
think
Section 8 company, but if it is a private company, it can take. In that particular section, in that slide where we mentioned that if that is Section 8 company, I think as regards cash flow, then it is to Section 8 company, it is not exemption is available. It is specifically provided. So their Section 8 company, every Section 8 company has to give cash flow because it is clearly mentioned. But in this circular, if it is not mentioned that Section 8 company are carved out, you can take them because your basic character of private company remains. That's why you set up as a private.
In case of the right issue by the private company, and the shareholders actually renounces to the third person, is it shown as a third position within the, what is it? Acquiring the amount.
No. In case of right issue by a private company and the shareholder renounces it to third person, is it allowed? And the third person who is acquiring renunciation can apply for rights. That is the question. In right issue, renunciation, any renunciation is made to third person, whether that will be since it will be outside person, whether it is allowed. So here also, as we mentioned, that article govern. So as per the Companies Act, right issue in private company, it was 1956, Sudhakar, that was there, that right issue only for public company. Now, under 2030, private company also come that way only. So, in this scenario, unless article provide, you are governed by the article. Yashasvi and Sudhakar, you can add anything.
In case of a rights issue 62, as you rightly said, Deepti, it is applicable to private companies also. Now the question comes that as far as suppose if somebody is renouncing the shares, because renunciation right is available mandatorily under the 62 Act unless until the article provides otherwise. Okay. So when you are sending the offer letter itself, you have to very clearly say that whether renunciation right is available or not available. Then the question comes, suppose if the renunciation right is available in case of private companies, can they renounce it in favor of any third person? Because in case of private companies, the restriction of transfer of right, restriction on transfer of right is there. So that point of time, can you renounce like that? So that is also to be restricted as per the articles and in the letter of offer also. Same is the case that can they renounce it to more than 200%, then what will happen? Again, the same thing, your articles have to restrict that to how many persons a shareholder can renounce the shares. So you have to keep that if you want to have that private company privileges, you have to ensure that they are protected, well protected. Transfer restrictions are there, number of members are there, acceptance of deposits are there. That is the reason in the provisions of the Companies Act, they have clearly provided wherever the liberty is to be given or wherever the ease of compliance is to be given. They said that unless until your articles provide otherwise. That means what? You can provide in the articles in a different way. Then the question comes, can I altogether prohibit it? Can you prohibit the transfer of shares in a private company? Answer is no, because you cannot override the act. What you have to do is by that transfer restrictions you can impose upon. Completely, you cannot ban the transfer of shares to anybody else. You can say that in case, say for example, several JV companies, we used to have a clause that first right of refusal, you have to give it to the existing shareholders. Suppose there are two joint venture partners out there. One joint JV partner wants to exit. So the exit mechanism is to be inbuilt in the JV agreement, which is to be incorporated in the article suitably. There, what we will say is, by the first right of refusal is to be given to the existing shareholders. In addition to that, also it is advisable to have the pricing mechanism, how you will value the shares at that particular point of time. Even that also you have to address that issue in the JV agreement itself, so that at the time of any kind of dispute, you should not scratch your heads how to go about it and all. Because once that scratch comes in the relationship, it is very difficult to bring them around the table. So when everything is cordial, that point of time, you have to say the exit mechanism. I still remember that whenever I used to give my lectures on JV agreements, I used to say this is the only occasion before the marriage you have to decide about the divorce. If I have to take a divorce, how I will do it. If you shy of that, you will be in trouble. Yeah.
Yeah, next two questions are relating to that. I think you elaborated. I will go to the next one. How restriction of the transfer of the share can be ensured when the member can actually transfer as our private company has obtained ISIN number?
Yeah.
Yashasvi, you can take it or should I take it up? See, when your private company shares are dematted, it is not like that without your permission that shares will be transferred across the demat. It is not so. In case of private companies and closely held companies, there is a provision of lock-in is there. So you have to lock in your ISIN. And as and when you want to open that, you have to give instructions to the depository that for this particular purpose of the share transfer, you have to open that particular folio, whatever it is there. They will open it only for a particular day. It is not like that in perpetuity they will open that. They will open it for one day only and to allow that transfers whatever is permitted by the board. And normally what the depositories also do is for this kind of lock, opening the lock and closing the lock, they will charge some fees. I don't know at this point of time how much they are charging. At one point of time, they were charging 10,000 rupees per event.
And you can direct register also, because they know that it's a private limited company and there are restriction on transfers and all that also.
So
So they
registrar
know.
may not be there na, in case of private company. It is directly the company is dealing with the depository. So
Yeah.
you have to give instructions to the depository only, not to the transfer agents.
Sorry. Yeah.
Yes, but the depositories have asked certain documents, like they have to sign certain documents before they are transferring. So without the director permissions, we cannot transfer the shares.
Yeah. See, that's why when you are opening the demat account, especially in case of private company and public company, if I am not wrong, the depository agreement also have this kind of clauses. Okay, so you have to go through that, and then this whatever you are mentioning about the procedural formalities are there. Those formalities are to be done because you have to move an application kind. You have to talk to the depository because say for example, sometimes it may so happen you have a JV partner and your shares are dematted and you want that shares to be transferred on a particular day. So you have to be you cannot just, okay, call the depository and today morning and you want to complete the transaction today itself. It may not be possible. So you have to be in line, in touch with the depository that, look, I have to open this thing for the purpose of this transfer. A particular day, what are the formalities and all, understand it clearly. Better to complete the formalities beforehand so that you won't have any kind of unnecessary unpleasant situations. So the company secretary or the compliance officer here, he has to be proactive.
See, they are service provider. What kind of service we want, we have to discuss and accordingly get it done.
Yeah.
As per our article. Yeah. Next.
What about the wholly owned subsidiary private company? I think they are talking about the restrictions, I think.
Yeah. If it is a wholly owned subsidiary company of a public company, this company becomes a public company. And only thing is that the difference between a wholly owned subsidiary company is that it is permitted to have the shares to be held in the name of others. That means though the holding company is holding 100% equity in the subsidiary company, because it becomes a public company and you need to have 7 members, the 6 members can be your nominees. And you have to file a declaration under Section 89 for that purpose. Beneficiary holder.
ROFR clause is applicable on pledge of shares.
Yeah. Yes. It all depends again the same thing. See, for example, in case of private companies, whether you will allow, first of all, the pledging. That itself is a big question mark. ROFR is a different thing. Right of first refusal is later it comes to. But to my knowledge, most of the private companies, they don't allow you to pledge the shares. Tata Sons example is the major one. They have not allowed Shapoorji Pallonji to pledge the shares.
Private company can accept the borrowing only from its directors.
We mentioned the public finance banks and all that, they can do that.
That means it means you are not a private limited companies are exempted from filing the cash flow statement. That we discussed actually elaborately said whatever it is. In the practice, limited companies not listed bypass the various applications laws of the RPT transaction and they indulge in intercompany transaction left and right center. Somebody is putting a view, I think so. Cash flow statement and threshold limit is also there. Even subsidiary companies below 1 crore capital at the reverse of the surplus are exempted. That's also information, I think so. I think you already said I beg to differ when it came to the Section 8 company, but anyway, law is like that only. Okay. Which are the company registered under the Special Act? That also I think we talked on that.
Like SBI Act and all is there, whereas banks are under specialized.
IRDA, insurance companies also, they have the specified act.
No, these companies come under special act only. Through act they are set up.
Yes.
So they are also there because they are governed by that particular
Yes.
act.
Yeah, life insurance corporation, for example.
Yes.
Yeah. If the Indian entity is a 99% subsidiary of the foreign company and the Indian entity is shareholding as per the small company definition, is it required to still go for the demat of the shares? I think small companies are exempted for the demat of the share. I think specifically they are not required to do the dematting if it is a small company.
Yes, you are right.
Yeah. Maximum violation from MCR from private companies. Yeah, that is true. That is what we will have to take care. That is the whole idea of this discussion today. We will have to ensure, because most of the cases which are coming in the private company, because many companies, they do not have the company secretaries per se, number one. Number two is there, whenever the compliance is done, it is actually not done fully. That is why the things are there. It is very true.
See, Bala, in fact, recently in one of the forums where I was speaking, when I said that, same issue has come up that several private companies these days are being penalized by the ROC and RD. I said that who is to be blamed for that? According to me, it is the company secretaries only. As PCS, we are advising them. Then they say, sir, our advisors, they don't comply with what can we do? Okay, then you have to see that whether you want to act as an advisor or not. And similarly, that means what you are not able to explain to that promoter or directors of a private company. But if you are not complying with my advice, this is going to be the consequences upon that. But as you rightly said, these days, the that several private limited companies are getting penalized with huge amounts of penalties. Whenever I read those adjudicated orders, I feel very bad about it that are we really servicing our clients appropriately? We have to introspect that.
Sudhakar has rightly said, who is responsible for compliance? Either the employee company secretary or the practicing company secretaries. as you rightly raised the point, is practicing company secretary has definitely educated the people and ensure the compliance is done. That is not happening. That is the issue.
No, but that is also the fact that even though it is many time advised, the promoter do not listen. Then they see the consequences, and then they next time at least will ask first that, oh, we face this, and at least we can. But it happens also even though they are told, because the tendency among them are there that, oh, when it will come, we'll file and we'll pay. Why at present we have to do that? Kind of also tendency is there in certain promoters. That is also the fact.
I
That
agree.
might be one of the transactions, because nobody will say ki, by that if you are touching a burning coal, you will burn your hands. Still, that fellow will go and touch the coal, the burning coal. I have my own apprehensions about it. Yes, what you say is correct. Sometimes what happens is that you are running a business, you have to take some business call. But those are exceptions.
Yeah.
But these days, in rampant this thing, it is happening. This adjudicate orders, Bhala is writing, I think, 2-3 articles per week. And if you read those articles, it is blatant violations. Minutes book not maintained properly not initialed, paginization is not there, signatures are not there. Which promoter will say, no, I won't sign the minutes, or I won't sign the initial this thing? Even see, sometimes Mr. Mukesh Ambani, when he was not initialing the minutes, we used to send it back to him, and he used to do that. And we used to, after the Companies Act 2013, even he has to put the that even the place where he's signing the minutes, we used to ask him, please put the date and the place. He used to do that. Why they won't do it? Because I fail to understand sometimes when the people say the promoter doesn't listen. It is by exception, maybe. That also where he takes a business call. That is entirely different. He knows that, yes, I will see the consequences, but as of now, I cannot comply with. Sometimes it happens. But there also you have to say, sir, this is a compoundable offense, this is a non-compoundable offense. I think to a large extent, no promoter will take a call, business call even, for a non-compoundable offense. Nobody wants to go to the prison here.
Dipti, whatever you say, ultimately, at the end of the day, we'll have to actually bring the compliance culture with the organization. We'll have to say, as you rightly say, some of the cases will be there, one and there, few, but that cannot be by and large all. That should be the case. Some other, unfortunately, by looking at the orders, it appears things are different. Okay.
Number two, Dipti, that when a company secretary says nobody listens to me, I really get agitated. Only for one reason. See the amount of responsibilities what you have been entrusted upon. And you still say that nobody listens to me. You have to make the people listen. See, regulator has given the support to the company secretaries who are the compliance officer, that your reporting is directly to the board. In fact, there are one or two informal guidance is there from SEBI, wherein it says that the one level below the board means, can he administratively report to somebody and functionally report to the board? They said no, level means it should be just in the organizational hierarchy. He should be one level below the board or one level below the managing director. In the organizational hierarchy, not reporting. So functionally also, administratively also, he has to report to that particular point. Much of support has been given by the regulator. But tomorrow he will say, when we said this thing, still you say that nobody listens to me.
No,
There's something wrong with you.
I was referring PCS, not employees. Yes.
Even PCS also, but you have to take a tough stand. Maybe a time has come. If you compromise on the compliance, you will be in trouble. At the same point of time, your client will be in
Not
trouble.
while certification, that we always give, but when they are doing corporate action and certain things, we give the opinion that many times promoters do not believe or follow or intend to follow. Then the notice come. We are advise them. So then next time they come in advance only. That only I was referring.
In OPC, DIN is not actually mandatory for the nominee member. In case of eventuality, the nominee member shall become a member. If the same person wants to become a director, how can we actually obtain the DIN? Since the mandatory for the proposed the director in the company, how it can be handled in an OPC?
I think so, sir. We should file the DIR 3 form. In that, we need to attach the resolution of this OPC company and the DIN number we will allot it. Then after we can file this form DIR 12.
If there are common
Okay.
direct, yeah,
I
if there
don't
are
think so. It is not correct.
Yeah.
See, you have to have a person as a director only who has the DIN.
Yeah.
Okay, if that person is not there, that may, in fact, immediately you have to make an application for that. And I don't think DIN is taking a lot of time. DIN may take in a 2-3 days time, you can get it. So you have to get that, and then only you can appoint that person. Subject to getting the DIN, you cannot file DR3. It won't be accepted according to me.
Yeah, that cannot be done. Because unless until you have the DIN only, it can be done, and the appointment of the director also cannot take place without a DIN.
Yeah.
Earlier, that used to be the case, subject to, but that is all done away with now. If there are common director between the two companies, which are the holding company and the subsidiary, then the section 188 will not apply. That's what somebody is saying actually here. Private company dematerialization of the shares of the holding, all the members share, how it can actually restrict the transfer of the share, that we discussed actually, he said actually. Whether such reduction of the notice period is required to be mentioned in the article. No, shorter notice, you'll need to have the provision, because if you are calling the shorter notice, it is there. Even the Companies Act, it is there. As the doctor said it very clearly, even Talla said it, if the article provides for lesser than the 21 days, 15 days, 14 days, even you want to call the meeting lesser than that, then that amount to the shorter notice, you'll have to follow the procedure. Can a gap of 3 days before the opening of the issues is to be reduced? This question,
For rights issue, he is asking. For rights issue, he is asking. That is for 7 days actually for other companies. That in case of private companies,
It can
they
be
can,
less. We discuss this.
yeah.
We could be grateful if you could share the checklist to us. I think we have to talk to them one-to-one. We can get the previous slide team. No, the recorded webinar will be available. That's what I said. Can a convertible note be received in the two tranches of the 25 lakh rupees in each tranche?
Well, how this is connection is there? Take next question.
Ma'am, that 25 lakh is with respect to deposit exemption.
Deposit, she was talking. There was a slide was there on the deposit thing. For fundraising for the smaller company, there was a slide with reference to that. He is asking the question.
So, you want to answer?
Can a convertible
The
note be
question?
received in the two
By
tranches?
dividing the transaction into two, you cannot avoid the compliance. That is the answer to that.
It means the private company can accept the unsecured loans from the relative director, irrespective of what they are if they are the shareholders.
It is written director or shareholders, right?
Yeah. If the two private companies which are also holding the subsidiary, but are also related due to the common directors or relative of directors in a holding company, being the director in a subsidiary company, will section 188 exemption apply? If two private companies, which are the holding and subsidiary, but also related to the common directors or relative of the directors in a holding company, being a director in a subsidiary company, will section 188 exemption apply?
See, you have to say that common directorship has nothing to do with the related party relationship. Okay. Other things you have to say whether it is applicable or not applicable. But by merely a director is there at two places, that doesn't mean these companies will become the 2% shareholding clause is there. If it is more than that, and you are a director, a common director, then it becomes a related party. Otherwise, not.
What will happen with such a declaration given by the director, even though they have borrowed and given it to the company depositor? That means they're giving the money from their own funds.
Non-compliance. It's non-compliance. So the implications of non-compliance. Yeah.
Director on abroad, can we get the digital signature in the financial of that directors? I think he's
Answer is
talking
yes.
fine.
Technically,
Answer is yes.
answer is yes, but only thing is, you should not show him as if he is signing on the same date where the board is signing it. See, because what happens is several people make a fox pause here that if the board meeting is being done today, there are say 5 directors are present and 1 director is not there, and 5 directors signed on one particular date, and the other director has signed it. I mean, by digital signature on some other day. And if it is a listed company and you are circulating the annual report, the date what you are putting should be carefully, you have to take care of that appropriate.
Sudhakar, you're right. Actually, there have been actually cases, different director, the different location, they had signed different dates, but they all put the common date of the same date of the board meeting date. ROC has taken the very serious view on that.
Yes.
How can the same person being in location A can also sign in location B also at the same time? What about the transfer time? They raised this issue. Company has been actually penalized to that extent. Okay. What is the minimum period of the notice can be mentioned in the AOA? Whether AGM can be held virtually.
We discussed.
Yeah, we discussed this actually. Can a private limited company to its directors give bank guarantee or other company, either private or the public is given, let me know the formalities for the company giving a guarantee.
So they are telling corporate guarantee.
Can a private company can give a director a bank guarantee
No,
to other?
Can a private limited company and its director give bank guarantee to other company, either private or public? If given, let me know the formalities for the company giving guarantees. So the private company is giving corporate guarantee for other company, or the directors of private company giving guarantees. That will be personal guarantee. So that is governed by the directors, personal guarantee. But when the private company give the guarantee to other company.
So they are gets triggered. 185 gets triggered, and there is certain exemptions are there. That private company has to be an eligible company to give that loans or the guarantee under 185. If it is eligible, yes, otherwise no.
Virtual meeting is now going to be disallowed. Virtual meetings, so
we
long
don't
as MC,
know. At present, it is on. That's it.
Yes.
Thanks for the wonderful webinar. Please clarify whether the exemption of the section 188 related party transaction companies will be available for a private company, which about 40% of held by a listed company body corporate.
Shareholding has nothing to do as far as your related party relationship or related party transactions are there. Okay, so 188 is still applicable to that private company.
Okay. Loan from the directors in a private company limited is outside the ambit of the deposit, even though DPT3 is required to be submitted. Is it private company limited takes a bank loan and no other loans? Will it require to submit the DPT3?
The private limited companies per se, they are not outside the ambit of deposits. Again, Tulna has mentioned that it is subject to certain conditions. So you have to see that whether you are complying with the conditions. If you are complying with, then you are out of the ambit of deposits. Otherwise, you are within the ambit of deposits and you have to ensure necessary compliances.
Can a private company limited issue DVR share in the face value valuation report required or not?
See, there is no prohibition as such for private companies to issue DVR shares. So other things are okay as far as when you are issuing whatever the other compliances are there as per the act, you have to comply with. But to my knowledge, there is no prohibition for a private company to issue DVR shares. Because especially in case of a JV company, I can envisage that DVR shares. One JV partner may not be, he may say that, look, I want to have more voting rights, and the other party may concede to that. In such case, you can issue DVR shares.
So, except
you-
provided in the Companies Act valuation report it is not required, but keep in mind in income tax it will be covered, and the stamping and all that, there the issue will come into picture. So that's why people, even though you don't advise in the only Companies Act angle, income tax, surely the company will be in a problem.
Can you
Yeah.
elaborate on the place of the AGM, that is city and the circular? I think probably he's talking about that municipal limit, I think so. Because if you actually see the MCA circular which is issued, which says actually, because the permission is the meeting can be held in the town village where the register office is actually situated. But where the MCA is actually issued a circular, I think way back in 1988, we'll have to look at the circular. I do not have it readily available. But it actually said there, city limits, what is the interpretation? That is what the circular said. Because it is set a postal limit or municipal limit, whichever is actually there. That is the thing it is set actually. Although the postal limit may be beyond the municipal limit, then also it is applicable. That is what the MCA circular is there. You have to go back to 1980 to refer the circular. Because I had a same instance. We actually held the meeting something about 25 kilometers away from the limit. Because if you are familiar with the Pune, our office was situated in PCMC municipal limit. But if we held the meeting at the Pune Municipal Corporation limit, it was a Pimpri-Chinchwad municipal limit. It was beyond the Pimpri-Chinchwad municipal limit, but it was the Pune municipal limit. But the postal district pin code was the same. So that is why we could actually held it. That was the case actually. Because somebody raised this issue, that is why I distinctly remembered way back in 1990, we done that, the circular 1988, which was actually there. You have to go back and refer. So the pin code, even though the pin code may go beyond the municipal limit, you can have the meeting done. Yeah. It means AOA of the private company should add a restriction in the voting, only poll does not violating the ACT. I think we discussed actually the restriction, other thing elaborately actually. Can the voting right should be changed irrespective of the holding percentage? I mean, can that be done by number of shareholders, only one member, one vote? No, that also he said, she said actually the number by value, he said actually. Very nice session going by all the land. Can I have the PPT on my, I said earlier, again, he was asking the PPT. Can this threshold of 20 companies may exclude subsidiary or a deemed public company? That also, I think he said actually what is to be done. You have to resign from one of the company. Internal auditor, statutory auditor, or statutory auditor, Yashasri, I think.
That internal audit requirement you mentioned, no?
Yeah.
Yes,
It
section
was
138.
internal audits is specifically mentioned that.
If 3 directors and 3 shareholders having a 2 holds 46%, 1 hold 50%, query, can 48% remove 52% director if the fraudulent evidence are available against 52%?
There is a removal of director, entire process is there. You have to go through that.
Appointment of the scrutinizer is required in the private limited company or for the e-voting if member are less than 1,000.
Yes,
Appointment.
once you go for the e-voting, obviously you have to comply with the entire procedure. Appointment of scrutinizer, he has to scrutinize. Otherwise, who will do that?
Exactly.
Then what is the purpose of e-voting otherwise?
Who will observe?
In rotation of the auditors, is 5 years cooling period applicable upon the resignation of that auditor?
अरे प्राइवेट कंपनी है ये, इसमें ऑडिटर का क्वेश्चन आ गया, ले लो.
Private company, it is not there, I think so.
And they have asked regarding rotation of auditor.
In case of private companies also, if it fall under the class of company, I think that 2 terms of 5 years each is there. It is
Yes.
not like that. It is not applicable for private company. It is applicable for private company also. Okay, suppose if an auditor resigns in between, and whether the cooling period of 5 years is there, technically yes, the cooling period of 5 years is there. If at all you want to reconcile with that auditor and you want to appoint him, yes, after that cooling period of 5 years, then you have to do that.
Whether the branch auditor of the public company is required to sign the branch balance sheet as per the Schedule 3, or he can only sign the trial balance of the branch?
You don't need to sign the branch balance sheet.
For
There is
all the
no need
direct,
to, there is no need to prepare even a branch balance sheet also. It is not mandatory. Branch auditor is supposed to do the branch audit and he has to submit his report. That's it. He don't even need to certify the trial balance.
for all the directors, deposit of rupees 1 lakh required, including the independent directors.
I think
Sir,
he's
this
talking
is
about a deposit.
candidature.
Yeah,
Candidature.
candidature. Yeah.
For private company, that is not applicable. Only in case of listed companies and for the class of public companies, it is applicable.
Normally, auditor of a private company limited is confined. Its auditorship for a long period, say 15 years, 20 years after getting the appointment of the rotation of the completed, or filing the ROC forms, even if such area is a non-compliance. Then
Is
again, you
not
need to see the class.
question.
Yeah. Normally,
No, the
audit
question is normally
yeah.
auditor of private limited company
for a
continued its auditorship for a long period, say 15, 20 years after getting appointed by rotation and complied of filing
filing
ROC
ROC.
forms, even if there is any non-compliance. See, this is what I was referring. Auditor question they are asking auditor appointment. Our thing is about private company. This is for the rotation and all that they are asking.
Okay. Shall I get the presentation? Okay. In the case of the private limited company, is he required to attend the auditor in AGM or can get exemption? No, auditor attending is something different, but you know to send a notice to him per se, whether either private company, public company, whatever company, the notice is to be given to the auditor in all the companies.
And every time you're, yeah, please go ahead.
Yeah. Section 8 limited company, whether required to have audit company, whether required to have the audit company. I'm not getting the question. What is it? Section 8 limited.
Audit committee.
Audit committee. Okay, he is written audit company.
So since this is a Section 8 public limited company, so they are asking whether that audit committee exemption is available to Section 8 company. Was all we are talking about private company, you have asked this question of Section 8 company and audit committee.
Even in section 1 section 8 company also, it may be a private company, it may be a public company.
Right.
Okay. So if it is a private company, obviously audit committee is not applicable. If it is a public company, per se, it is applicable.
Yeah.
As most of the private companies conduct the AGM the last day of the September. I don't know what is the relevance of this particular question.
Okay.
MCA contains the borrowing. How do I get leave of exemption by the auditor from the attending the AGM? How to get the leave of exemption of the auditor from attending the AGM?
He has to seek the permission of the company. Next.
If the panelists may please explain DB private company and the public company in terms of the transferring free restricted, how ROFR class we framed for partner companies. You know to get in touch with one-to-one in
yeah, it's a JV company and then all drafting. It's a lot of facts and you have to sit with the promoter, JV partner and all, then it gets.
What happens to the SCA is not made part of the A? Is it mandatory to make SCA equal with the AOA?
It's SHA is a decided case. It's years long that Supreme Court has said that any contract which has provisions which do not within the framework of Companies Act will not be will have overriding effect unless it is part of article. So everyone has to make it part of article. It's very old one. You have to make it.
Can we incorporate the clause of AOA for
Here also, when you say it is making a part of it, you cannot have this thing, my shareholders agreement is part of my articles. That kind of clauses will not work. You have to incorporate the appropriate clauses of your joint venture agreement in the appropriate articles.
At the appropriate places. Where the quorum, there you write quorum relevant. Where the voting right, there you write voting right. Pick up from that SHA and then you write.
Yeah.
Dipti, I see there are a lot many questions are there. We are already at 1:08.
we can go fast. I think many are
If
there.
any important
Oh.
questions are there, pick it up now. Answered questions, you'll leave it.
Okay, can we encounter the
Now
class
don't
AOA
take
for
auditor and all that, huh? Because we are with a private company now.
can we encounter the clause AOA allowing the company to borrow the relatives of the directors? Can it be done amendment by the AOA? Yeah, we discussed this elaborately. Once the board was actually in the deadlock, chairman used the costing order. However, it was argued that the CV can be used for the circular resolution. Can
A
ordinary
circular
courts of
resolution,
business,
you cannot use casting vote.
how ordinary courts of business can be defined for RPT?
You refer to our RPT webinars,
RPT
there we have
session,
explained
yeah.
it.
This is referred to the section 92 of the filing of the annual return for the company. I
Hey,
am not
1
clear.
minute, huh? Mr. Bala, this was interesting. Can we incorporate clause in article for allowing company to borrow from relatives of directors? Can it be done by amendment in article? Boss, you cannot breach the law by amending article. In article, certain exemption is allowed. You can increase, so you can be stricter that instead of 2 quorum, 2 members, or 2 directors, I want minimum 3 directors. That all is allowed. But what is not allowed in the law, you add in article, you cannot. Yeah, take it.
Section 6, you have to refer to.
They refer to the section 92 of the filing of the annual return of the private companies. I am not clear on the rationale for providing the link to the annual return for the website, if any, if there is no public interest involved, while there is a provision for abridged return of 7A for the small company, the website class, it will be applicable. It may be better to stipulate threshold on the borrowing, etc.
I know what we cannot comment on the law at present. What we have to.
Can a private Section 8 company appoint a CEO who is also a non-executive director? What are the companies it needs to do? Okay,
You have to see that whether that Section 8 company is a public company. For that, 203 is applicable. Then you have to comply with 203
No,
provisions.
it's a private company they are telling.
Private company they are saying.
Section 8
private company, that 203 is not applicable. Only the CEO is there.
I think we have to clarify, except that one exemption of cash flow. Again, we are clarifying. Section 8 company can be private or public. Once you are setting up Section 8 company as a private, all the provisions of private company is applicable, except where it is mentioned that this exemption or this provision is not applicable to Section 8 company, they have to comply. Then you have to take that compliance. If you are public company, then you have to follow the provisions of public company. Because it's very clear, private and public you have to comply. In addition, Section 8 company. Yeah. Next.
What are the additional exemptions in case of the Section 8 companies over and above? What are the available in the small companies and vice versa?
That is, we have to look at for Section 8 company. That is also our webinar is there. Yeah.
Excellent presentation. Difference between the key person and the directors. I think you have to read the definition section to know this answer. Exemption section 188 is still available to the exemption notification issued earlier, and now whole section has been amended.
Exemption under section 185 still available as the exemption notification issued earlier, and now whole section has been amended. I think it's a comment. Okay, check.
Is it significant shareholders of the employee in the company and find the director will be deemed as a director? If a significant shareholder is an employee of the company,
this is not
a
relevant
director.
Topic. Next.
Okay.
Deemed director, they are telling. These are different dilemma. Deemed director, control and composition, that way it is.
Okay. Very important, the valuation presentation, it is important. Those who are actually associated with managing both public and private. Okay. It's a comment actually. Post incorporation, can we change the initial subscriber of the MOA and AOA before the subscription money has been received from the initial subscriber?
Next. This is not for the presentation. This is another thing. Yeah, next.
can the same person be appointed as the company secretary in two associated private and crossing threshold in the paid-up share capital of the company?
Next.
I think subsidiary
Next,
company you can appoint.
Mr. Bala, private company, now everything, RPT is coming, then everything is coming, we can't answer.
Okay, synopsis by the profession. KMP is intended to be read with the plural. Okay. Does the KMP CS need to be
Again,
in case
see,
of
everything coming, KMP question is coming. Boss, KMP is discussed by us in a different webinar.
independent director? We talked about it. One director, we talked about it. I believe except demat of the securities, other exemptions available to the Section 8 company being a private company. Yeah, that also we talked about it elaborately. As well as the transfer of share, private limited are registered to the transfer. What are the this also we think we discuss about transfer elaborately. What will be the quorum of the AGM from the private limited company, which is subsidiary of the public limited company?
Mr. Sudhakar mentioned that very
Sudhakar
clearly.
elaborately explained on this, whether valuation report will be recorded in case of the right issue.
No.
In case of
That
the
we
ISA,
discussed.
in case of the ISA debit, yeah, this we talked about it. Can the loan from the shareholder be more than 100% of the paid up share capital of the reserve, and with the providence not associate subsidiary or another company if the borrowing is less than twice the PD paid up capital of the share capital, where is no default is filing a financials? Can the loan from shareholder be more than 100% of the paid up capital and free reserve? Then you have to see what is permitted. Na? We cannot go beyond what is permitted in your article or even the company's act. You have to read with both. A private company which has no operation during the year 2025-26 and does not see any of the foreseeable future, can the remuneration to the director and other personnel? I think this will skip. Virtual meeting
Say
is
a private company which has no operations during financial year 25-26 and does not see any foreseeable future can pay remuneration to its directors and other persons. See, as regards Act, there is no operation is not relevant. Your financial, and for private company there is no restriction. So you have
private,
to check the same.
Private company no ceiling limit applicable. What they want, they can do actually. That is the thing. Virtual meeting is going to be disallowed in future anyway. That is as on today it is allowed. Can the debenture of the private company be listed in the stock exchanges? Yeah, once you list the debenture, then you become a listed company, whether it is a private or public. Three type of companies comes under the special category. That is banks, insurance, and electricity companies. Okay. Private companies are considered as a company secretary work in the cost centers. Okay. If you have the nil operation for the year 2025-26, then can we go to the voluntary winding up? That question is not relevant here. Is it okay if instead of initials the signature is done by the chairman? Is it okay instead of initials?
Full signature, fine, okay.
Yeah, more than required. You mentioned a little earlier that WOC private limited company of the private listed companies need to have the 7-member shareholders, but in reality, there are several companies, WOs, which do not have the things understanding of the department clarification. Can you please clarify? I think Sudhakar elaborately sparked, once you become a deemed public company, what are the compliance required, what is need to be done? He specifically touched upon the annual general meeting quorum, which is required 5% actually. Promoters are listening to CS, okay. Dividend has to be paid within 30 days of the declaration.
No, it is dividend question.
Yes. In some cases, there are no mention of the borrowing powers of the AOA, but in the MOA, is it mentioned, but the company can indulge in the borrowing if it is appropriate?
It's borrowing is not allowed.
Should be there in articles.
Yeah, it has to be there in the article. That is there. Then the next question
What
actually
we discussed is about bank we were talking. What I and Yashasri was mentioning, that you take a loan from the bank, which is that we were mentioning. And that also we said that better you mention clearly that though borrowing is the private company can't do, means specifically that provision for national bank you mentioned. Yeah.
I understand filing of the special resolution MGT 14 is applicable only in case of the public companies, or is that or some resolution which will have to be filed in the private companies also? If yes, what are those?
Sir, may I speak?
Yeah, please.
Yeah, go ahead.
Yes, so special resolutions are to be filed by private companies as well, not just the public companies. The exemption is given to the resolutions
Policy.
passed by the board of directors in exercise of their power under section 179 and not to the special resolutions.
To the related party transaction or a private company can be approved at a extraordinary general meeting.
Yes.
The webinar was really useful. Okay. Out of the 5 shareholders, the private limited company, only 4 shareholders have attended the annual general meeting. Another shareholder holding 15% of the share is absent. Will it be treated as a non-compliance?
You can't have AGM with there is no quorum.
Yeah, 5 people in person. That is a quorum actually. Not there.
But he's telling 4 shareholders have attended.
Only 4
Four
man.
attended, na? You
But
require
that's
5.
for private companies, the
Deemed
quorum can
deemed
be
public
less.
company.
He's telling private limited. In private it is. I don't know why he's asking 4 shareholder in private. Next.
Oh, okay, if it is a private limited company, yes, 2 is the quorum.
There are only
If it
2
is
is
a public,
sufficient. Yeah. Well,
if the public limited company, then it is 5 actually.
Ah,
Okay.
that's right.
Okay.
Could the directors DSC be affixed on the minutes of board meeting?
See, again, it is whether you are maintaining the minutes in the physical form or you are maintaining in the electronic form. If it is the electronic form, yes, DSC can be used. If it is a physical form, then you have to sign. But again, you have to have everything in a digital. I think we discussed one of the webinar earlier also on this. Rotation of the auditors applicable to the companies for the following class as somebody is giving a information. Do we need to DPT 3 for loan from the directors and members? Do we need to file DPT 3 for loan from directors and members?
Yes, sir, it has to be
you have
filed,
to.
and we have to select the radio point wherein the amount is not considered as deposits.
Okay.
But we do
Yes,
have to
yes.
mention the amount in the section, in the provision where it mentions.
Audit committee requirements are applicable to the public companies of the capital 10 crores and above, public compliance turnover 100 crores and above, public company with the loan borrowing, etc. However, the wholly owned subsidiary
He's
companies that
giving
will not.
answer. He's giving the provisions.
He is giving a provision. Okay. Is it okay instead of initial full signature? I think it's the same question which is repeated again. Should the related party transaction of the board meeting be approved at the extra? That also you answered, I think, question again coming here. Can the director use personal credit card for the company's payments? Can a
Yeah,
director
use and then reimburse. There's a
you get it reimbursed. That's the question.
confusing it is. Yeah.
Yeah.
I thought some legal thing is there.
In the AGM of the private company limited, only 4 out of the shareholders hold. Yeah, this also again the same question which is repeated again.
Yes.
Can a private limited company provide loan to the managing director? I feel not allowed. If provided, what is the alternative compliances requirement if prohibited under the Companies Act 2000? Can that be considered as a salary advance to the director?
185 is exempted for private companies subject to certain conditions. If you flout that conditions, you cannot give the loan. It is a non-compliance and it is a criminal consequences are there for that. Somebody is giving an information valuation report will be called by IT. Thank you. Kindly answer. Can the director take a salary which is significant to the next level and also claim insurance pertaining to him, which is actually significant to the profits to rupees?
Profits and turnover. See, the
profits
private company, there is no limit. We mentioned that it is. That's why.
Yeah, private limiteds are out of the purview of the ceiling limit of the remuneration only. They are governed only for the appointment. That's all. Nothing else is there.
I know.
Okay?
This is initial.
And full signature we talked
is
about.
better than initial, better compliance. No tension. Please don't. It's okay. Answered. Okay, Shruti.
Yeah.
There is no problem. Because
If the
fourth
DPT
time your
is,
question is come, so anywhere your initial is there and director, chairman, anyone give full signature, no problem. Don't worry. Okay.
if the DPT is not filed, will the cause any issue in the new AOC 4? What is that? If
I
DPT
think
If
these are two separate forms. Filing should not be a problem. DPT they not filed, non-compliance will be taken.
I think that is all. I come to the end of the questions. So
Okay.
let us.
Tulna, your first maiden presentation is such a grand success. Having so many questions,
Thank
I
you
think
so
this
much,
is the
sir.
highest questions we have ever received on this topic. I never thought a private limited company's topic will be so successful, and you presented it very well. Full compliments to you, Tulna.
Thank you
But
so much, sir. Thank you so much.
great,
Really, this today's webinar is very excellent. Now the time is 1:25. And we have been discussing this question for the past more than 45 minutes. We have been talking only question and answers. Nothing
Not only
else on
that,
that.
in fact, this time, Yashashree has brought very finer points, which, in fact, we have not brought it, but she brought it, that thing. Thanks very much, Yashashree. And future also, we will bother you to come as a panelist for appropriate picks. Please oblige us.
Yeah. Thank you so much, Mehta and Mehta,
no?
for inviting me as a panelist. Thank you so much, Bala sir and Sudhakar sir. Thank you, Tulna. It's a great presentation. I think so 300 plus participants in this Janmashtami. So it is like a great opportunity to interact with everyone, every professional in this particular platform. Thank you, everyone.
Thank
So
you.
in
I am
case,
really.
if anybody missed out, the past webinar also, we are uploading in our YouTube channel. So you can visit our YouTube channel and subscribe to that. So thank you, Yashari, for a nice listening and wonderful you to have in our platform. And we'll bother you again and again. Don't worry.
Arthur, you want to announce for 200th webinar as such next week?
Yeah, so we'll be having a 200 webinar. It's again a very big milestone for Mehta and Mehta. Probably I remember we started sometime during those COVID time, and since then there is no stoppage of this webinar. Thanks to Bala sir, thanks to Sudhakar ji, and probably all our panelists who always supported us whenever we called them. So thank you, sir. And probably, Sudhakar ji, you wanted to say something on this? The second, you wanted.
So that definitely, we have some great plans for the next week's webinar, as this is going to be a significant milestone in Mehta and Mehta. It is the 200th webinar. And we are thinking to do something big. And let's keep our fingers crossed. Wait for our announcement. Thank you.
Thank you. Thank you.
Okay. Bye-bye.
I am really highly delighted to see the number of participants, the number of questions, and it shows really the thirst of knowledge and learning from many people actually in our profession. I am really highly delighted to take note of this. Thanks a lot to everybody. Thanks, Dr. Sudhakar. As usual, you are vibrant. So, Tulna, your excellent presentation, my great appreciation to you. That is very clear. Because I was also thinking today being a Janmashtami, at least some 100, 125 people will come. That is what I thought actually when I joined the webinar. But the moment I looked at the figures, my God, great. Thanks a lot. Thank you.
Thank you.
you.
Thank you so much,
Thank you,
sir.
everyone.
Thank
Thank
you.
you. Bye.